Influence of any type of medication or drugs that would prevent you from knowing what you're doing?
Yes, sir.
Did you read and sign this plea and sentencing form agreement?
Yes, sir.
Court finds pleas admission is freely and voluntarily entered. Court accepts it. On case 21 CF 2214, you're sentenced to 12.1 months DOC, credit for all time served. Court recommends DOC drug treatment facility. You're not sentenced as a youthful offender in 22 CF 1129. Court sentenced you to 12.1 months DOC, credit for all time served, concurrent and coterminous with 21 CF 2214. You're not sentenced as a youthful offender. Revoke and terminate supervision, all unpaid costs to judgment. Anything else?
Just one thing for the record, Your Honor. Ms. Harper scores 26.8 points. I have printed the guidelines. Is it okay if I submit them in a few minutes? I have to physically go pick them up from our office next door.
Okay, that's fine. Anything further?
That's all I have.
Thank you.
Thank you, sir.
Who's next, Marnie? What number is that on the docket?
That's a good question. I did not bring my actual dockets.
Michael, is it Bullabo?
Bullabo, yes, sir.
Bullabo?
Your Honor, Tim Gibbs on behalf of Mr. Michael Bullabo. This is 21 CF 2621, 21 CF 2633. Judge, yesterday we submitted a motion to continue. I'd spoken with Ms. Barrickman about continuing this hearing. She did not enter an objection. Ms. Leone, I believe, can also speak for her on her behalf for that.
That's correct, Your Honor. No objection.
We're requesting May 25th, still with subpoenas at 2 p.m.
All right, granted.
Thank you, Judge. Judge, I also have a Mr. Dante Corey in the audience. Judge, his case number is 23 CF 16. He is not on docket today. He apparently missed court on Monday for pretrial. He came into my office yesterday to indicate that he had missed court. He is here this morning. We'd ask that the capias be recalled, Judge, and leave him set for June 26th for pretrial.
The state does not object.
Okay, so it's Dante Courtney,
Corey, C-O-R-E-Y, Judge.
and he's not on the docket because he missed court.
He missed court on Monday, Judge.
I'm going to recall the capias, but next time you got to wear long pants to come to court, okay? All right.
Thank you, Judge.
Okay, thank you.
Give me a call. Make an
What's
appointment.
what's his next court date?
June 26th, Judge, for pretrial.
Dante, June 26th. Okay.
Thank you, Judge.
Don't wear shorts or in my court to the bailiffs. Or hats.
Yeah, May 1st or May 4th. Yeah, May 4th.
Is Mr. Bonneau, sir?
Is it John Bonneau?
Your Honor, Tim Gibbs on behalf of Mr. Bushner. This is 22 CF 590, 22 CF 1406. Judge, I'd like to put this for next week on May 4th in the morning without subpoenas to try to get it resolved. We're still talking to the state about trying to get it resolved.
No objection, Your Honor.
Okay. May 4th. Mr. Madden, can you hear me back there?
Yes, sir, I can.
Okay, good. It doesn't sound like I'm picking up on the microphone.
Oh, no, it's projecting back there.
Okay.
Your Honor, Tim Gibbs on behalf of Landon Carter, 20 CF 1749, 22 CF 2208, 22 CF 2242, if I could have just a moment.
Oh, here it is, behind the computer. I got it.
Judge, we just, I think, just reached an agreement on this. I don't have a written plea. If the court doesn't mind, I can certainly announce the terms for these cases on a plea agreement.
You want to go ahead and, why don't we just take a few minutes to fill it out?
Okay,
And
certainly.
just take another person, and Ms. Rivers can do one, and,
Thank you, Judge.
okay. Mr. Anderson, good morning. Okay.
Morning, Your Honor. John Madden here on behalf of Yaquan Anderson. There's two cases, I believe, on your docket, 21 CF 2788 and 21 CF 2789. But violation of probation is the allegation. We would be entering a denial today. We have been in talks with the state attorney's office, but we would like to set this, because of Mr. Anderson's designation, he's not eligible for a bond, so we'd like to set this at the next hearing date for a hearing or a plea agreement. I believe it's sometime in May, but I could be mistaken.
Well, I mean, how much time do you think you need?
Um,
Wanna
Judge,
get-
it's a technical violation. I think, an hour to be safe.
An hour for a technical violation?
It could be less. I always hate to run out of time.
If I may, Your Honor, I just need enough time to communicate with probation officer about the allegations of the violation.
Why don't
It
we-
may be the case that we may reach an agreement, so there is not going to be need for any court
Want to bring him
time.
back about May 4th? Is that a day?
Yes, sir, it is. Okay.
And then,
But if I may, Your Honor, I may not have time between now and May 4th. We have docket day on Monday, we have court tomorrow. I cannot promise that I will receive a response from probation by then. So I would ask a later court date.
right there.
No, it's not. Unfortunately, Your Honor,
Some recommendation, I don't know if it's one that's long.
Yeah, let me talk to you first.
it's Officer Farnsworth. It's not Officer Berry. That's the reason.
Well, okay. We'll put him for May, what, 20-something? 20, was it 20?
25th?
25th, but if you can figure it out, then can we move him to May 4th?
Absolutely, Your Honor. There is no issue with that.
Try to get it resolved?
Yes, Your Honor. I will do my best to get us in here by then, but we'll see
Okay.
what Officer Farnsworth does.
All right, we'll do that. How about that? Okay?
ma'am.
All right, thank you.
That's all I have, Your Honor. Maybe excused?
Yes, thank you.
Morning, let's know who you want next.
Carter.
Carter?
Carter, I'm writing it up right now.
All right, we have Landon Carter back.
Your Honor, I'm completing that written plea just as we speak.
Okay.
Getting the details finalized. Hoping that it's still legible.
Mr. Carter, would you raise your right hand, please, to be sworn? You swear the testimony you give for this court is the truth, so help you God?
Yes, sir.
Thank you.
I need 90 days in jail, credit for time served, concurrent. Fees, but we'll give you 180 days to pay. So they'll revoke and terminate your probation. You've got to do 90 days in jail with credit for whatever you have on the underlying charges since you've been in on the VOP.
Wanted to make sure.
If you would please sign right there for me. Today's date. You have 180 days to pay that before it goes to collections. If I may approach, Judge.
Thank you. All right, Mr. Carter, you want to enter an admission to case 20, CR 1749, 22, excuse me, is it CF 1749, 22 CF 2208, 22 CF 2242, all are violations of probation, possession, well, we don't need to go into the original. You know what you were on probation for. You want to enter an admission to those three cases? Okay. Has anyone forced you or threatened you to enter this admission? You happy with the work Mr. Gibbs has done on your case for you? Did you read and sign his plea and sentencing form agreement? You're under any type of medication or drugs that prevent you from knowing what you're doing? Court finds the admission freely and voluntarily entered. Court accepts it. The court revokes and terminates probation, 90 days, Okaloosa County Jail, credit for time served concurrent on each case, total $300 cost of prosecution, $550
$350, Judge.
$350 PD fee, 180 days to pay. You write just as bad as I do.
I hoped it was legible at least.
All right, anything further?
I don't have anything further,
Okay,
Judge.
how much time has he served already?
He's pretty close. He may very well have it day for day, Judge, overall. So that.
All right, don't get in trouble in the future, okay? Thank you.
I appreciate it.
Doherty? He's out of custody, but I can address him if we want to grab Doherty. Yeah. Judge, I do have one person that I believe is out of custody, Brian Crocker. He's here, or he's supposed to be here on 2 VOP cases. Judge, he also has a new law violation case in 23 CF 626. That's set for tomorrow afternoon. I don't see him here. I don't see a response to a Mr. Crocker in the courtroom. I'd ask to leave him set for tomorrow afternoon for plea day, since he's already scheduled for that on his new case.
Okay.
I do see that his
So may not have contact info for him.
All right, so we'll just keep him on the docket for,
Brian Crocker.
what day?
Tomorrow afternoon, Judge, is a plea day, felony arraignment day.
I'm not doing that.
Different judges covering. I believe Judge Jones is covering that.
Jones,
Or
Rasmussen,
Judge
okay.
Rasmussen, okay.
Tomorrow?
Yes.
All right. All these judges been like, kind of like a buffet, hadn't it? You know, various styles and,
It's been interesting.
okay, next case.
Your Honor, Tim Gibbs on behalf of Miss Alexis Doherty. This is 21 CF 2080. If I could have just one moment. Just come right here.
Okay.
May I have a second, Your Honor,
Sure.
to find out from probation?
So we're gonna see. Original on the case. Any other previous? Judge, we're still negotiating with the state. Can we set this for next week, May 4th, in the morning without subpoenas?
That's fine, Your Honor, no
Okay.
objection.
How much time has she served already?
Judge, she's been in the jail this time since, if I'm not mistaken, I can actually pull that up. This VOP judge, she's been in since March 15th, so she's got a little over a month now. Underlying case, it looks like she may have
All right, well, bring her back.
2 months. Yeah. You can just go ahead and go back that way. I think that just leaves Ms. Cornish.
I think, are we at Ashley Cornish now?
Yes, Judge.
All right, this is a VOP evidentiary on 22 CF 1735, 22 CF 1803, 22 CF 1879. Twenty-two CF 3006, 23 CF 26, 23 CF 294. Call your first witness.
Your Honor, Ariana Leone for the state. First, before we proceed with the actual evidentiary hearing, I need to place something on the record. It came to the state's attention that the affidavit of probation does not include the addendum that relates to the new law violation of arson that Ms. Cornish committed and she was arrested for.
Hang on one second. Is she represented by,
She represents herself, Your Honor.
okay, and she has been representing herself?
Yes, yes, Your Honor.
Sir, if I may, I was appointed standby counsel for the sole purpose of providing her discovery from the state. Judge Mason had appointed me a month or so ago so that we could make sure Ms. Cornish was given discovery while she was in jail.
Ms. Cornish, you still want to represent yourself? You have every right to a court-appointed attorney. You understand that?
Yes, sir, I understand that.
And you want to continue to represent yourself?
Yes, sir, at this time.
Okay.
In reference to what she was speaking on about the,
Let her finish first.
yes, sir.
Okay, go ahead.
The violation of probation, Your Honor, per the affidavit filed by probation officer Berry, alleges several grounds. Some are technical, some are substantive, like she committed 3 new law violations. If this defendant has to be sentenced on all the cases, including the VOPs and new law violation, first of all, she's a violent felony offender of special concern. She was on probation for armed trespass, and she committed armed trespass. The score sheet show a total points of 160, which translate into 99.6 months in DOC. The maximum sentence she's facing for all the charges is 25 years in prison. The state is seeking imposition of the guideline sentencing. At this time, the state will be ready to go forward on proving the violation of probation on the technical grounds, and will seek, in the event the state is successful, to set the VOP cases for sentencing on May 25th. Because the state will request a danger hearing due to the status of Ms. Cornish being a violent felony offender of special concern. I would only ask, Your Honor, before we proceed, to allow me 15 minutes to speak to my witnesses and connect all the equipment to go forward.
Right. Now, what did you want to say?
I wanted to say that one of my witnesses did not come this morning. She feels intimidated. She feels that she is scared to come and testify. Now, I was hoping that perhaps we could possibly have a continuance so that I may speak to her again in hopes that she would come to testify on my behalf. I do have one of my witnesses here today, but I do feel as if my case rests on being found not guilty as if Ms. Caperletti were here to testify.
Well, have you had a continuance yet?
I have not, no, sir.
You realize in a VOP hearing, it's not a trial by jury. You
I do.
understand that? And there's a different standard of proof. It's a preponderance of the evidence, not beyond a reasonable doubt proof. You understand that?
Yes, sir, I do.
That the trial is just before me, and you could be convicted on just a technical would be enough to convict you on a VOP. You understand that?
I understand.
And so, did you subpoena this person?
I did.
And your other witnesses showed up. Who is that?
This is Elaine Kimber Matthews, my mother.
Okay. Well, she's asking for a continuance so she can have her witness.
May I be heard, Your Honor?
Yeah.
This case was heard on Monday in front of Judge Oberlisen. The state at that time requested a continuance of the hearing to May 25th. This defendant objected to my request for a continuance, and she insisted that we do the hearing this morning. It is not proper for this defendant to play with the court's time and with the witnesses' time. I have law enforcement officers who came from Pensacola for this hearing with a very, very short notice. That's first. Second, the state objects to any and all witnesses the defendant tries to introduce. One, I haven't had the chance to even know who they are. The state is caught by surprise. I need to have a chance to depose them. So I would ask that those witnesses be excluded for the purposes of the hearing today, if we're going forward.
May I be heard?
Yeah.
I have given the state my witness list twice now, and the state was provided with my witness list on the 10th of April. So therefore, that is ample notice for her to have had time to deposition them.
She says she provided her witness list to you.
Your Honor, we addressed again this issue on Monday in front of Judge Oberlis, and mentioned to this defendant that the way to share witnesses with another party has to follow certain rules. She handwrote the names of these people in the back of a letter that she sent out. That's not proper discovery sharing.
Well, are you wanting to, well, here's somebody, who's this?
Probation, Your Honor.
Well, I'll get to know you. You're not in trouble, don't worry. Well, you said you wanted to take her witness's deposition.
If she intends on using them, of course, I have a right, Your Honor.
Someone's here, right?
Yes, I don't have a court reporter, and I'm not prepared for any deposition right now. And I have witnesses who came from Pensacola.
Your Honor, in lieu of the state not wanting to proceed at this time, I believe that it's in my best interest, instead of taking it to trial, because I'm not sure that my witness will show up, and I am worried about taking everyone's time. I would like to just, at this time, change my plea to guilty of the violation of probation, and as it stands, and plea guilty as charged to the existing violation of probation grounds, and plead out to you, Your Honor, and allow you to sentence me. Based on my points, that would be,
How about, if you want to do that, how about me appointing a public defender? How about that, to go over guidelines, to go over your guidelines, your score sheet?
I have my score sheet right here, sir. Excuse me, I did not mean to interrupt you.
What do you say about that?
Well, first I would ask that she be placed under oath, Your Honor.
Okay. Would you raise your right hand and be sworn? You swear the testimony you give for this court's the truth, so help you God.
I do.
For the record, she admitted the violation of probation. Your Honor,
Are you talking about just now?
just now, yes.
No, she didn't. She said she wasn't under oath. She said that's what she would like to do, and plead up to me, and I didn't make a decision on that yet.
Well, then I would ask Ms. Cornish to state what she wishes to do.
All right,
And she's under oath right now.
all right, and you're recommending 99 months? Is that what you're recommending?
I didn't say that, Your Honor. I didn't recommend 99 months. I said that's what she scores.
Oh, what are you going to recommend?
Would you be amenable to a 24-month plea agreement? 24-month DOC time?
No, Your Honor, what I would be reasonably amenable to and agreeable to would be 36 months DOC for everything.
I agree.
All right, you got the case numbers and all that for me?
Yes, Your Honor,
That's
I
the problem
just...
with having different judges. It's not y'all's fault. It's Judge Oberlis is presented with a set of circumstances. I'm presented with a set of circumstances. We're trying to do the best we can and be fair to the state and fair to the defense. And I'm not trying to rush anybody, but if she wants to plea for, I guess, 36 months to take care of everything. Credit for time served? Is that
Of
what-
course, Your Honor.
All right. You got a plea form?
I have a blank one, Judge.
I mean, she said she had one already, didn't she?
I have this one, but it's
No,
marked
the
up.
score sheet, Your Honor. She doesn't have a plea form. Mr. Gibbs is well prepared.
All right, you got a recommendation from the state there, Mr. Gibbs. You want me to appoint Mr. Gibbs to go over that plea form with you and fill it out? Or
Yes,
would
sir.
that cause problems with the public defender?
Or I'll fill it out. My handwriting's good, so.
All right. Fill it out, Ms. Leon.
I have a lot to write because it's like
Why don't we take, is we done for everybody except for this case? You want to take about a,
Ms. Rivers, you have something? Oh,
you want to take about a, what, 15-minute break?
15, Your Honor. It just should be enough, please.
Okay, well, good. We'll do that. And I want to make sure you understand, I'm not forcing you to enter this plea, and the state's not either, okay? You can have a hearing. You understand that?
Yes, sir, I do.
Okay, all right.
Thank you, Your Honor.
15 minutes.
15 minutes.
We talked about, you print it?
Of course, I'll print. That's the least I can do for you.